examples of, excuse me, non-discrimination language, most of which I pulled from the Fair Housing Office of the Department of Housing and Urban Development. And it just gives you some examples of generally what your non-discrimination obligations are and the type of information that you might want to include in non-discrimination notices. And I should say that, like the other information we're going to be talking about, all of this is required when you receive federal funds, either directly as a recipient of them or indirectly as a subrecipient through a place like the city of Loveland, for example. So yeah, as you can see in the underlined portion, these obligations are the same for recipients, direct recipients, as well as subrecipients. And the having non-discrimination notices, the good way to go is to, if your funder, let's say in the case of Loveland, in the case of HUD, if they have specific language that they include in sample notices, you can never go wrong copying exactly what your federal funder is doing, recommends, or posts. That's like your bulletproof until they decide to change, which they ordinarily don't do. So this, I think it's a good idea in these notices to explain exactly what it is you are doing and what non-discrimination obligations that you have. So this it's also important in your notices to explain that if you believe you've been discriminated against, you can file a complaint here with FHEO, and also give the public contact information for your program. So that's contact information for you, name, email, phone number, and excuse me, contact information for your federal funder. Here, as an example, would be HUD. And this is just some good general information to include in a basic non-discrimination notice. And as you can see, it explains in the first paragraph that we comply with all non-discrimination laws. We shall not discriminate on the basis of the protected classes that you can see here. And then the second paragraph, that we're committed to essentially non-discrimination policies and exclusive policies. And I don't know if you saw this, I think this was yesterday. The Biden administration announced that for all, excuse me, organizations receiving funding from the Department of Health and Human Services, that the Biden administration would be enforcing sex discrimination to include gender expression, gender identity, and sexual orientation. So that's a change from the previous administration. It's something that I expect all the federal agencies will be doing. It is consistent with the Supreme Court's decision last summer in a case called Bostock versus Clayton County. So I expect that if your agency hasn't told you this yet, they will be. It's just a matter of time. So this is basically, excuse me, a summary about non-discrimination notices. And again, they are required. They must be conspicuous. Don't do what some organizations showed me, excuse me, they were doing. They showed me their brand new non-discrimination notice, and they decided to put it in an obscure part of their offices that were not open to the public. And I explained to them, well, that's not really conspicuous because nobody can see these notices except you. You need to bring your notices out where everybody can see them, and that they need to be conspicuous. You know, playing games and just hiding them from the public is not a good idea. If there is some type of excuse me, federal investigation or federal inquiry, to say that you've hidden essentially your notices in non-conspicuous places just puts the feds in a bad mood and sets you off on a course that you easily could have avoided. So that's it for non-discrimination notices. Now let's talk about the Title VI of the Civil Rights Act of 1964. That's the law that essentially requires federal assistance recipients to provide language assistance to people who are limited English proficient. And as you can see in the main paragraph of the statute, it's pretty basic. It protects against discrimination on the basis of race, color, national origin. National origin under federal law is the same as language-based discrimination. So Title VI operates if you receive federal funding. It only applies to these categories of discrimination. So there's nothing about disability, sex discrimination, or religion, for example, race, color, national origin, with national origin including language. And this does not apply to private businesses that don't receive federal funds. So for example, McDonald's is not covered by Title VI. It is covered by other federal non-discrimination laws, but this one just doesn't apply to them. So once you receive that funding, either directly or indirectly, then Title VI essentially becomes your best friend and is part of your legal obligation. Excuse me. As President Kennedy said in 1963, when he introduced the Civil Rights Act to Congress, the genesis behind this law was to prohibit discrimination, not surprisingly, by entities that receive federal funds. As Kennedy said, simple justice requires that public funds to which all taxpayers of all races contribute not be spent in any fashion which encourages, entrenches, subsidizes, or results in discrimination. This is an area of law that is not controversial in the sense that it's being regularly decided and revisited by the courts. This is what lawyers call well-settled law. It's well established. It's been the law since the 1970s concerning language assistance. So it's not something that's changing. It's not something the Supreme Court is reconsidering. It's pretty much a done deal. This is a really fascinating story that I wanted to share with you to show you how the reach of Title VI. So this is reported on Houston Public Radio in March that the Federal Highway Administration has stopped construction on an interstate highway in Texas. This is, as I understand, a $7 billion project. The FHWA intervened because of complaints of racial discrimination under Title VI, as well as also some environmental justice concerns. I think the last paragraph really says it all. According to former general counsel of the Federal Highway Administration, this is a big deal. It just doesn't happen very often. And I would agree with that. During my federal service with the Justice Department, we never did anything like this. And I never came across anything where such a large project was just stopped well into its life. This is not a new project. So this really shows you the power of Title VI. If the federal government decides to employ it in all its aspects. So it'll be interesting just from a curiosity standpoint, how this investigation plays out. The whole notion of a language access plan is also pretty well settled under federal law, according to the Department of Justice, various court cases, and this one in particular. This is a case involving the School District of Philadelphia in Pennsylvania. Here, the federal court said that a language access plan is required for predominantly Spanish-speaking parents who are limited English proficient, who have children in the Philadelphia public schools. So court did not take a lot of time in its opinion saying you have to do this. It pretty much echoed what we've already discussed. Yeah, it's well settled. You take federal funds, you have limited English proficient people in your service community. Yeah, you really need this type of plan, and it is required. So the next few slides are just some examples that I've pulled from various federal funders that give you a broad overlay, broad description of key parts of your language access plan. There are some more involved parts of planning that we're not going to discuss in the next 45 minutes or so. But this is just, it's a good way to begin if you have not already begun. It's a good way to look at your plan to see, oh, we don't have this and we need to include it. So there are 5 basic sections that I'm going to talk about. The first one is, what type of language are we talking about? Doing some type of needs assessment. And that involves your having some type of information about the needs of current and prospective customers and consumers whose preferred spoken and written language is not English, including how many people are there that you see who don't speak English? What languages do they speak? How often do they interact with you and how do they interact with you? So one of the ways to do this is, not surprisingly, having a gathering survey information, keeping track of the number of people that you see daily, weekly, monthly, for example, to see what languages do we see? Is it possible that over 6 months you see no one who speaks a language other than English? Sure. I think it is likelier than not that you will see people. The most likely language that you'll encounter, given the demographics of your general part of Colorado, would be Spanish. But it's not as if you're not going to encounter people who don't speak other languages. The first step is you need data. If you don't know now whom you see who speaks what language, you need to get it. I did language access plan work for a large city on the East Coast in the last couple of years. They have been receiving federal funding for decades, and they had no idea, and I mean no idea, the number of languages they encounter on any basis, daily, weekly, monthly, yearly, which is a significant problem with being able to serve the community and also with their legal compliance. Because essentially, how do you know what languages to have ready for people who may come through your door unless you know the people who come through your door? So start with a survey, daily, weekly, monthly. That's a good place to start. It is likely that for each one of you, you will have different experiences than your colleagues in other organizations, because not all people patronize, visit, inquire with all organizations on an equal basis. So start with, how often do you see people who don't speak English? Daily, weekly, monthly. That's a good place to start. By the end of by mid-June, for example, if you started today, you'd have a pretty good idea of languages, at least over the last month, and that will allow you to begin the planning process, and also be aware that whatever languages that you do encounter may change. But starting with that survey is really important. The second section is, what kind of language services do you provide? Do you provide in-person interpreters? Do you have video remote interpreting? Do you have telephone interpreting? And we're going to talk a little bit about translations later, but what documents do you translate? How do you decide which documents to translate? So as part of your survey, you should also gather information about what pamphlets, materials, online resources are people asking for? What are the most frequent asks, so to speak? And you'll typically find that documents and materials that enable people to access your services, some type of permit, some type of registration, those typically are among the most frequently requested documents or materials, and they would most likely need to be translated. And we'll talk about that in a little bit later on. But what I also wanted to mention with language services is, if you do not have video remote interpreting, you need to get it, like, now. I had a question the other day about, actually I did a training for counties in another Western state. And I got a question about, well, we come from a small city in a rural community in a relatively small county. Can we be exempt from doing this? And the answer was no. Once you take federal funding, there's no exemption. There are differences depending on the size of the county, the size of the organization. But their concern also was, we don't really have a large number of any in-person interpreters here. So can we get some type of immunity from providing language services? The answer is no. That's why the video remote interpreting is absolutely essential, because it gives you that opportunity to interact with your customer, your client, without having an in-person person in your office. Also, you avoid a significant legal issue of, well, I'm sorry, we don't have anybody here who speaks Russian, so we'll have to make an appointment for you to come back in a week. something we at the Justice Department refer to as turnaways, that's almost a per se form of discrimination. You don't have the services available to interact with people in the community who speak languages other than English. You're supposed to be ready. That's what the law expects. So I would look into video remote interpreting. There are a lot of video remote interpreting providers. The technology is not expensive. You can have include an app on your phone, on a tablet, on a laptop. You basically pay for the service as you use it. So if you're not using it that frequently, it's really important to just have it in your back pocket in case that day, hour rise where you do have people who don't speak English and you don't have in-person interpreters to be able to provide assistance. This is one of the overall questions, and the point of really having a plan is, as we just discussed, well, how do you provide language assistance? How do you determine what methods you use? And how, of course, do you find a good language service provider? I should tell you that I worked with a large organization a few years ago in Colorado who frankly had a lousy language service provider, and they were getting into some serious trouble, legal trouble, both in court and with federal agencies. So they had asked me for my opinion. My opinion was that you have to terminate the contract because they're not fulfilling the contract. The contract requires them to provide you with what is needed for you to comply with federal law. They're not doing that. You need to find somebody who can. And I think that they've breached your contract, and you can pursue whatever state court remedies you have involving a breach, but breach is pretty clear cut. You really cannot afford to have them as a partner who they're unreliable and they're hurting you. They're not helping you. The law requires that you are prepared to serve the limited English proficient population that patronizes you and also may patronize you. So one example is that if for some reason you have a large percentage of people who speak Tagalog in your service area, but they are not using your service, that could change tomorrow. So the fact that no one who speaks Tagalog has sought your service, even though they live in your community, doesn't exempt you from the possibility that they may. That's yet another reason to have video remote interpreting, because a good provider will be able, without any difficulty, to provide you with a Tagalog speaking interpreter in case the mix of people who speak languages other than English changes. So, again, this is just to reinforce what we were talking about, when to use these services, how to use them. If you don't have VRI, it's important to get it. VRI is much better than the telephone. I know the telephone can be a good fallback. If you get a good VRI provider as your partner, they likely will also be able to hook you up through telephone if the computer goes down, if your internet connection goes down. You need to have some redundancy in your compliance program and be able to offer a different type of service like the telephone, rather than tell people to go away and come back another day. Bilingual staff is something I'm going to touch on briefly. All people who provide language assistance under federal law must be trained and must be qualified. Federal law does not require certification, but the qualification is that you're fluent in English, in the target language, and you're fluent in whatever relevant terminology applies to you. So let's say you operate a homeless shelter, for example. There may be certain terms that are more relevant to your organization than to an organization that provides childcare. So that's really something that you can work with your provider to determine the skill level of your interpreters. Bilingual staff is generally not a good idea. A lot of people make assumptions about their language ability. I speak 3 languages other than English, and I'm pretty good in a couple of them, but I know I'm not qualified to be an in-person interpreter for someone who is limited English proficient and speaks French, for example. I know I'm not qualified to do that. So with bilingual staff, if they're going to be providing language assistance, Their abilities have to be confirmed through some type of assessment test. Your language services provider can help you with that, because you just simply cannot be using people who are not qualified and fluent. If you're using people who are not proficient, that is also a form of discrimination. The four-factor analysis is something that all federal agencies have incorporated since DOJ came up with this about 20 years ago. This is just, it's a good formula to use in figuring out the type of assistance that you provide. So the first is the number or proportion of LEP people in your community. Now that's each language. It's not as if you take all LEP people and combine everybody. You have to do this kind of sorting. Well, who speaks Spanish, who speaks Japanese, who speaks Tagalog, who speaks Polish, and look at the numbers of in the population. You'll start to get a handle on that once you do the survey that I was talking about earlier. The more frequently you see a specific language, the more you're going to need to do. The more information you may need to translate, the more people that you have available to provide interpretation will change depending on how often people frequent your organization, which goes to the second point. If you have people who speak Spanish using your services every day, then your obligation is broader than an organization that sees people who speak Spanish once a month. The more frequently you encounter LEP people, the more you have to have available to communicate with them. And it also, the nature and importance of your program. One of the examples that I use is if a city or county runs a state fair, a yearly state fair, do they have to provide language services? Yes, they do, but not to the same degree and in the same amount as a first responder would, because a first responder emergency services under federal law is just regarded as more important, more significant, more crucial to people's lives than a government office that operates an annual state fair. The last factor is essentially money, so that there is a lot of information that's already out there that you can use to enable you, to help you with your planning and your implementation. As you can see, you'll see in the next slide or two, the smaller the organization, the more limited the resources. If you're just running a two-person operation and your annual budget is like $20,000, you're not going to have to do as much as an organization with 30 employees with a budget of $200,000. But this does not exempt you from doing anything. There are a lot of organizations that see that and think, oh, we're really small, we don't have to do anything. And that's not true. So figuring out the frequency that people use your service, the languages that you see, and then looking at, okay, how much will it cost to do X, Y, and Z? I'm sure that there's a lot of sharing that can be done, which typically is something that's important. There are a lot of low-cost alternatives too, like universal symbols. And then you'll also see an iSpeak card in a few slides that you can get from the internet, doesn't cost anything, and can really help you make your program accessible to people who don't speak English. And this is the Department of Justice's view of with translations, that you use the four-factor analysis to look at how many people do we have coming in? What documents are they asking for? The law doesn't require you to translate every web page, every pamphlet, every form, every registration document. Only the ones that, you'll see the definition in a minute, are considered vital and most important for people to use to be able to access what you provide. So that's why it all starts with data, and all starts with knowing what your service area is, who the people are that you encounter, and the languages that they speak. So as you can see, the Justice Department certainly recognizes that smaller recipients with more limited budgets are not expected to provide the same level of services as larger recipients with larger budgets. Excuse me. Larger recipients should ensure that if they're claiming we just can't afford this, you have to document it. There've been many situations of justice rejecting, for example, claims that we just can't afford this. And justice there's a famous case a few years ago in North Carolina, and North Carolina said, we just can't provide these services to people who don't speak English because it's too expensive. Justice Department looked at their budget, they looked at all the numbers and said that the cost of providing these services is, I think, something like 0.002% of your total budget. So don't tell us it's too expensive, because it's not. So make the assumption that you have to provide some level of service. The level of service will differ organization to organization, community to community, and service population to service population. This is what is a good example of what needs to be translated. Under Title VI, there's a term called vital documents. Vital documents under federal law must be translated. But what exactly does that mean? So as you can see, Justice says that some examples of vital documents that need to be translated include forms, consent or complaint forms, notices of rights, like the notices of non-discrimination, letters or notices that require response. So think about whatever you have that explain what your services are, that enable people to access them, that enable people to file a complaint if they feel they've been discriminated against, notices of non-discrimination. Those are good places to start. That doesn't mean that there's nothing else that you need to translate. But I think this is a good beginning of what when you are in the office talking to your colleagues, all right, well, what of our thousands of documents, web pages, materials, what do we need to translate? Start with these. And this is, as I said earlier, if you're following what a federal funder says, particularly what the Justice Department says, you're good. I mean, I've never seen a situation where an agency is going to say, oh no, you can't do what we said. Do what they said. It's a good place to start. It's very reliable. Okay, the third section of your plan is notices. How do you notify people that you provide language services? How do you tell them that? Where do you tell them that? Posting something online, having something in your physical office, putting a notice of language services on a registration document or another type of form is a good idea. I think for the most part, knowing about the demographics of your general area, I think making the assumption that you're going to put information in Spanish is a good place to start. You may need to use other languages too, but Spanish is a good place to start. So having notices that say, if you're a limited English proficient and need interpretation and translation, please call us, contact us, and having that in Spanish, I think that's a good place to start. Posting that liberally in your organization, both physically and virtually, is also a good idea too. Training is really important. Justice over and over stresses the importance of training. I agree with that. The organizations that I've seen in my career that are the best position for compliance and have the lowest risk postures have the best training. And that's not 5-minute training. That's not only new employee training. It's explaining your non-discrimination policies, that they include language assistance, language access, explaining to staff how they can access interpreters, how to provide information in other languages, how they can identify the languages that people may be speaking, and that's what I'm going to get to in a minute. But it's a really important part of this training. Please avoid assumptions about what language an individual speaks based on how they look, based on their skin color, their race, their name. I have seen so many situations where there's an assumption that because someone has a name, let's say like Gonzalez, a name ending in Z, that person needs assistance in Spanish. where invariably, in so many cases, the individual will say, no, I don't speak Spanish, or I don't need assistance. And the organization, the provider, insists, oh yeah, you do, because of your name, and we have to provide information in Spanish. Don't make the assumption just because, as I said, because of how someone looks, that person needs or does not need language assistance. Please make it a big part of your training and policies for your staff, not to racially profile based on language, and not to make assumptions of need based on the characteristics that I've included. I have seen that over and over again. It never fails, if that does happen, to get the organization in some kind of serious difficulty, and a difficulty beyond what they anticipated. In the training, that you should also include information, as I said, about how exactly do we call our language services company? How do we do that? What happens if somebody comes in who speaks Spanish? How do we handle that? And that's all part of your training and explaining what your policies are. We have interpreters, we have in-person interpreters, telephone interpreters, video interpreters. Here's a fact sheet about how you access them. Good place to start. This is an example of something called an I Speak card. They're regularly available broadly online. And it lists Arabic, Armenian, Bengali, and Cambodian, for example. And the quotes, the languages on the screen basically say, I speak Arabic, essentially. So that if I come in and I'm speaking a language that isn't English, you train your staff to use these I Speak cards to help identify the languages that you're hearing. The odds are your staff will likelier encounter languages that can be recognized either by them, or the person coming into your office can pick out the language of one of these I Speak cards. This is also something that your language services company may have. They may have their own, but if you prefer to use something else, they are widely available. I should also make a pitch for obtaining federal grants. There was a famous story about 18, 19 years ago. An Ohio state of Ohio department developed this really cool set of flip cards that were laminated that could fit in your pocket. They were only like 5, 6, 7 inches high, maybe even a little more than that. And they had 50, 60 languages. They developed them with a federal grant. Didn't cost the state of Ohio a penny. Now they are among the more popular examples of I Speak cards. So this may be something that you decide you want to apply for as part of a federal funding, where you want to develop your own I Speak cards. The feds really love stuff like that. When I was with Justice, we looked at many grants. We would always wonder, why don't people ask for more funding or dedicated funding to provide language services? We never understood why people didn't do that. So I really encourage you to look at that, and that might be something that you might want to explore. These are examples of universal symbols. We see them all over. Universal symbols are low-cost ways to communicate with people who don't speak English. So I would encourage you to explore universal symbols as they may apply to services that you provide. The fifth section is evaluation. How do you know your plan is working? How do you know it's effective? How do you know it is meeting the needs of your community? So you will likely need to do the survey we talked about earlier, more than just like starting tomorrow, for example, particularly when the census data comes out for state and local communities at the end of September. That will give you a good snapshot of what the demographics are today for your community. That's a good place to start. But this is the evaluation process is something that's ongoing, and you may need to update how you provide the services we've discussed, depending on what works really well, what doesn't work as well. So evaluation is another component of your plan. And I want to switch quickly to the Americans with Disabilities Act. Americans with Disabilities Act, unlike Title VI, applies to every public serving organization. So all of you presumably do serve the public, and then you would be considered places of public accommodation. That includes nonprofit organizations as well as private businesses. So the ADA is somewhat of a broader law than Title VI. We're going to be focusing on the effective communications piece, but as I said earlier, I'm going to talk briefly about some other areas of compliance. So you receive federal funding, you're covered by the particularly funding from a state or local government. You're going to be ADA Title II, and I'm presuming that for purposes of today, you all are covered by ADA Title II. There are some differences between Title II and Title III. They're not really significant for the purposes of today. The Rehabilitation Act of 1973 is like Title VI. It only applies if you receive federal funds. So since all of you do receive directly or indirectly federal funds, the Rehab Act would apply to you. It's basically the disability discrimination equivalent of Title VI. The elements of the Rehab Act are similar to the ADA. The biggest difference is that under the Rehab Act, I can sue you for money damages, for punitive damages, for intentional discrimination. There are no money damages available under the ADA. It's only under the Rehabilitation Act. So what is an effective communication plan? And I think these are 4 key questions that you have to answer in figuring out how do you communicate with people who have disabilities? Well, the legal phrase to comply with the ADA is effective communication. Your communication must be effective for me as a person who is deaf or blind, for example. What are ADA appropriate auxiliary aids and services? We'll discuss that in a moment. When do you have to provide them? And who chooses the aid or service that will be provided? The answer for the last one is basically me as the person with a disability. It's not up to you to tell me how I should communicate with you. I tell you what my preference is, what my primary choice for communication, and then we go from there. So this is what the Justice Department says about effective communication. If you think about it, it's very logical that to comply with the ADA, you have to ensure that communication with someone with a disability is equally effective as communicating with someone without disabilities, so that my access as someone with a communication disability is basically the same as it would be for someone without that disability. These are examples of auxiliary aids and services, and this is part of a settlement agreement with the police department a couple of years ago. As you can see, there are a lot of different aids and services. There's using exchange of written notes, written materials, something called CART, or computer-aided real-time transcription, assistive listening devices. You can see video remote interpreting is right at the top. In-person interpreters would be also included. So these are your obligation to provide. It's not up to me to provide my own interpreter. It's up to you as a place of public accommodation or a recipient of federal funds to provide the type of auxiliary aid or service that I need, that I prefer to communicate with you, to be able to access your publicly available services. Although handwritten notes or typed text, they are acceptable forms of communication, they're not going to work in every situation. It's really important to remember that the ADA is a case-by-case, person-by-person law, that the type of communication aid that's being used or that is most appropriate will vary depending on my communication choices, my ability, how long we're going to be talking. If I come into your office and say to complete a form that I had started on the other day, and essentially all I have to do is sign it, then our interaction is going to be pretty brief. Assuming that I can understand written English, that may be all that's needed for you to communicate with me. It may also, The only thing you may need to do is just show me the form, point to what I need to do, hold the pen, and that should maybe enough for me to understand that I need to sign something. Please keep in mind that many, if not most people who are deaf, who became deaf very early in life or were born deaf, likely cannot read English proficiently. So your providing written notes to them is ineffective. And if you continue to do that after the person who's deaf says, no, this doesn't work, then that's disability discrimination. So please don't assume that just because someone's deaf, that person understands sign language. Same is true with Braille. Most people who are blind cannot read Braille or prefer not, that's not their preferred method of communication. So that's also partly why you don't go out and put 5,000 documents into Braille. Not only would the cost be exorbitant, but most people you encounter who are blind or low vision can't read Braille. So it's a case-by-case situation. And what is effective, as I said, is really going to be what works for me. So if I can't read English, then writing notes, I'm not going to pick that. I'm going to pick something else. Let's say sign language interpreter. So that's an important part of training. Just like we talked about the racial profiling under Title VI, excuse me, not making assumptions that people who are deaf must only communicate by sign language is a big part of training and staff education. So this reiterates what I had said before about the equally effective. There is an exception under the ADA that if the choice of communication, the choice of accommodation would result in an undue burden, would fundamentally alter what you do, then you don't have to do it. You can come up with an alternative. I've never seen that work. The standard for that to work is incredibly high. For you to say that we can't afford to do anything, we can't provide any type of assistance to someone who's deaf, there's no way that's going to work. So in your interactions, I really can't envision a situation where you would be able to conclusively argue that providing an in-person sign language interpreter, for example, is cost prohibitive given the level of interaction that you typically have. And as I said, I've never seen a situation where that works or has worked. So as I said earlier, it is not an option to tell people go away and come back some other time. You need to have the facilities ready and able to use immediately. That's why video remote interpreting is so important. There is a national shortage for the most part of sign language interpreters, in-person interpreters. So being able to go remote, which we've all gotten used to over the last 16 months or so, is a really important part of compliance. I can't stress enough that is really not optional. You got to have it. The feds expect it, and not in Colorado, but in the Mountain West. There was a situation a few years ago I was involved in where there was an ADA discrimination complaint. DOJ came in, and the counties and the state were not using video remote interpreting, and DOJ gave a very Washington speak kind of response that was basically, I hope that you will have video remote interpreting in all jurisdictions in the very near future. And the translation is get VRI as soon as possible, because right now you are out of compliance, you are discriminating, and you don't have a way of providing effective communication to people who are deaf. Under the ADA, just as under Title VI, you have to provide interpreters who are qualified. There is no certification requirement under federal law. There may be, and often is, in many states, but not all states. So the person you're using must be qualified, must be fluent in American Sign Language, for example. And as you can see here, some forms of communication may be ineffective for certain people, as we talked about earlier with written notes. Go with what the customer, the person who's deaf, excuse me, is requesting, is telling you. That if they say, I don't understand sign language, I don't understand this, then you work out, well, what works best for you. Excuse me. There was a court decision last year in New York State that said closed captioning is discriminatory for people who can't read English. Makes sense. And as I said earlier, not all deaf people can read English. So just using closed captioning will not be enough. Excuse me. Just as with spoken language interpreters, spoken language assistants, publicize that you're providing information to people with communication disabilities. And how do you do that? Put it online, put it on various documents and materials. You may need also to translate that depending on the service community, but whether you need to do that or not, keep in mind there's a good general paragraph. Publicizing that you provide assistance, making it widely available, and explain what you do provide. Talk to your language services provider about having a capacity to print in Braille if needed. That's not something you should start doing right now, but it's important to have the capacity to do it if the need comes up. These are basically the legal requirements for having video remote interpreting that's compliant. As you can see, most of the requirements are technological. Having an image where, like today, you can see my hands, the image is clear, it's not pixelating, not choppy, not blurry, not grainy. So if you have video remote interpreting and you have any of these technological issues, that's disability discrimination. If the person who is deaf, for example, complains, I can't see the image. This isn't working for me. So just having it isn't enough. You have to have all four of these, and it has to be working. Your Wi-Fi has to be dependable. You have to have enough bandwidth to accommodate VRI. And as you can see in number 4, you have to have training of staff about knowing how to work VRI. I've actually seen situations, and I'm not making this up, where in a hospital, for example, there's a deaf patient who has requested sign language interpreter. Hospital has VRI. Doctor and nurse come in and they ask the patient in bed, where do I plug in the computer? Do you know how I turn on the computer? So this is the doctor and nurse asking a patient in bed, do you know how I do this? Do you know how this works? Do you know where I even can find a computer? So making sure your staff knows what VRI is, how to work it, absolute. You really can't ask the person with a disability, hey, can you help me with this? Can you help turn on the computer or find the correct app? No, that's something you need to do. So as we talked about earlier, who decides? Basically, I decide as the person with a disability. And for purposes of today, it's really important to remember that you can't know what's effective for me to communicate. Only I know. And then we kind of have an interactive conversation about what's going to work in what services you have available in whatever given situation. Remember, the longer the situation, the longer the interaction, the more complex the conversation topic, the likelihood is you will not be able to use written notes at all. That the longer the conversation, the more complex the information is that we're exchanging, it's likelier that you're going to need an interpreter because written notes for an hour conversation, there's no way that's going to work. So the default, the longer, the more complex the interaction, the likelier that you're going to use an interpreter. And again, that's assuming that the person with a disability understands sign language. This is called the primary consideration rule. Excuse me, and it kind of just fleshes out what I had been talking about, that the person with the disability is the person best qualified to know what is effective and what works for them to be able to communicate with you. This is part of a settlement agreement between the Justice Department and I think a police department in Michigan. I think these are some good training keys, if you will, for staff that ask. Not every person wants to be helped. Not every person wants to be assisted. So I've seen situations where staff is very well meaning, but they insist on helping someone with a disability, for example, even though they don't want it. They say over and over, don't help me. Well, if you're doing something to me that I've told you not to do, you know I'm not going to like that. And you know I'm going to be unhappy. The level of unhappiness will increase depending on exactly what's being done to me or for me. So really important, don't assume that's just because someone is blind, for example, that they need or want assistance. Ask. That just asking will change the nature of the interaction and the communication very favorably. And you will avoid the assumptions that often 9 times out of 10 get people in trouble. Listen and pay attention to what I'm telling you as the customer about what I want, what I need, and what I prefer. Don't be offended if I say, no, thanks, I'm good, or I don't want any help. Don't be offended. I'm just expressing my opinion. So just go to the next step and then respond to what you're hearing, respond to what I'm asking you, respond to what I'm requesting. So avoiding assumptions in this context is really important. Sometimes it can be difficult for um, people in front facing positions serving the public. They may be very inclined to be helpful and to prospectively uh, provide help. Well, while I think that that may be a good personality trait, I guess, if you will, but it's not always going to be the way to go. So ask, listen, and respond are 3 really important keys for working with and communicating with people who have communication disabilities. And these are just also some good planning thoughts for your effective communication plan. Well, are there good local companies that can help you with auxiliary aids and services? Are there good vendors? Can the city, who does the city use, for example? Are there other entities that you receive funding from that may have some good tips for you? The documents in Braille, as I said, being able to produce documents in Braille is important. Don't start doing it unless you start receiving some requests, but just have that capacity. And the training at the end and also the qualified interpreter services, really important. And DOJ just emphasizes, and they don't always do this, the importance of training. And I agree. I think the ask, listen, and respond is part of this, having good training, a thorough training, good policies that are compliant and that enable your staff to comply with their obligations and your obligations under the ADA are really important. These are my quick run through of non-communication areas. The ADA also has requirements for structural accessibility, and they're included in this publication called the Standards for Accessible Design. And they include everything from the height of water coming out of your water fountain to the width of a doorway and the width of your disability access parking spaces and the number of spaces you're required to have, curb cuts, all kinds of things. So it's really important to understand that these are as much requirements as the effective communication piece. If you have a barrier, if your doorway is not 36 inches wide and it's 28, for example, and I can't fit my wheelchair through, you're discriminating against me. That is illegal. So that I really encourage you to have get an outside expert to do some type of physical assessment of your physical facility to see whether you're compliant with the ADA. And part of that is this is self-evaluation or assessment. The federal law requires that there be, by 2012, compliance with the standards of accessible design that I showed you, and for you to have a transition plan about how you're going to become compliant, not when, not if, how. And the how is going to have a relatively short time frame. And these are just some examples of what you would have in a transition plan, what physical barriers do you have, how are you going to resolve them, what's your schedule for taking care of them. Those are really important elements in complying with the ADA structural requirements. Briefly about the internet. One of the big areas of federal civil rights litigation is website accessibility. The numbers of lawsuits have grown each year successively, with the exception of our pandemic year last year. Often I find that websites are not accessible. Sometimes that's because the designers, the webmasters, they have their own preferences for what websites should and should not have, but their preferences are not always legal. They're not always accessible. So do you have an accessible website? And if not, when are you planning to make your website accessible? Service animals, I just included this because I get so many questions about this. And I think the law is very simple. Often the devil's in the details, and the implementation is harder for many organizations. You can only ask someone 2 questions if that person has a service animal. Is the dog a service animal required because of a disability? And what work or task has the dog been trained to perform? That's it. You can't ask me to have my dog perform the task. You cannot ask me what the disability is. You cannot ask me for a proof of training, or you cannot decide that certain breeds of dogs are not service animals. You can't do any of that. And there was a big case in Denver, actually, a few years ago, where that involved an organization, I believe, saying that pit bulls weren't service animals. Can't do that. Federal law doesn't say that. Under federal law, all dogs are service animals, or it can be, I should say. You can tell if a dog isn't a service animal if the dog starts jumping on you, barking, running around, having accidents. Then that dog is not a service animal. It's disruptive. You can ask the dog to leave. Ask the person to remove the dog, but not the person. The person still gets the services, but you can ask that the dog be removed. The only other animal that can be a service animal is a miniature pony. Miniature pony that meets certain size requirements. That's it. There's no such thing as a service animal: cat, iguana, bird, tiger, nothing. It's only dog and miniature pony. And that's it. So as I said, I wanted to include the service animal piece because I know that's an ongoing issue. There's a lot of misunderstanding about how to handle service animals. But please keep in mind only those 2 questions. That's it. Also, don't get fooled by dogs wearing those vests that you see. Hi, I'm a service animal. There's been a lot of abuse of that. You can buy those vests pretty cheaply online. That by itself doesn't mean that the dog is a service animal. Just watch the behavior. If someone says that their 80-pound dog is a service animal, but that dog knocks you over, put the dog out. That dog's being disruptive. So I hope that today was helpful. Let me stop screen sharing and we can do questions.
Bruce, there are a couple of questions in the chat.
Okay.
Pam Brewer asked for more information about assessment tests for bilingual employees. And as a follow-up to that, did you say that certification is not required?
Certification is not required under federal law. I can't speak to what is required in Colorado. Frankly, I don't know, and I'm not a Colorado licensed attorney. But federal law does not require any type of certification. Federal law only requires that you be qualified, that you're fluent in, let's just say, French and English, and fluent in whatever the relevant terminology is for your organization. That's it. State law may be different. There are some states that have very strict requirements for certification. Some states have none. So federal, none. State, it just depends on your state. And I'm sorry, what was the first part of the question?
Information about assessment tests for bilingual staff to make sure that they know. Mm-hmm.
Yeah, I'm sorry. I talked to your language services company. that's a good place to start. And just as a caution, I had been retained by a small healthcare provider on the West Coast because they were concerned that their provider was recommending a test that like 98% of people would fail. And it seemed too complex for their needs. So they asked me to evaluate how they were assessing their staff. And they were choosing basically between two types of tests. They were very surprised when I chose the, I don't want to say the easier test, so let's just say the less complex test, because the idea of testing is you want there to be some people who are qualified to provide language services. Then you can't provide like a second grade level proficiency test, but having a PhD level test for an interpreter, that doesn't make any sense. So this provider went to the less complex test. They started to identify staff who had some levels of language ability and then would assign them given their proficiencies and the needs of the organization. So that worked well for them. So first start with your language services company. They may be able to help you. If not, there are companies that are out there that do a better job than others than assessment. So first thing is start with the company that you have and go from there.
Thank you, Bruce. And I got a little bit of more information in the chat. For the city of Loveland, we use a service called Telelanguage, and we have had people certified. And I would say that that would be one way to understand their ability.
Yeah, I think that's a great point. The law doesn't require, the law, I'll put it another way. The law allows you to self-certify in the sense that you can have your own, develop your own test. You don't have to get some university to design a test for you, not given the interactions that you're likely going to have. So as Allison described, you have a good provider. They can help you with an assessment test, and that may well be all you need. So you start with the provider, as I said, and see what they can do to help you put together or put together for you an assessment protocol.
It's a lot of material. What other questions do you have?
I have a question for Denise.
Yes.
Yes.
Denise, I'm curious if you have any feedback about using, I think it's called TDD, but so people who have a hearing disability can communicate over the phone.
Yeah, we use it all the time. We also have a deaf interpreter. So we have lots of means to communicate.
I wonder if you could share that service provider for the TDD with this group, maybe, because we would be interested in learning more about that.
Sure, give me
Thanks.
just a minute.
And we do have, Disabled Resource Services, and I'm going to say specifically Denise, are some experts in our community who have so much incredible knowledge in this area that she's always been willing to share. So I would, send her an email and reach out to her for her area of expertise.
Hey, Allison, this is Tracy with Project Self-Sufficiency. How are you?
Hi, Tracy.
Hey, I'm curious. I missed the first one. John attended. I'm coming in cold on the second one. What I really want to understand is what other supports besides exposure to this information is the City of Loveland going to provide the funded nonprofits? Is there a plan for that?
So that's a really, really good question and something that I was going to hit on at the end, but I'll jump into that a little bit right now. So summer of 2019, we had some mini trainings to help people in 3 areas. So we had 3 mini trainings. One was creating just your basic policies on ADA. That was the first one. Title VI or non-discrimination. And then the third one is having a grievance policy that your customers can access for either one of those. So we had 3 one-hour trainings to help people get on board. Now, Bruce went over a lot of that at the very beginning of this. Your policy should contain this and this and this. And that's why I said you might want to dust them off and read them. The experience for me was that people followed the instructions, but the purpose of this is to make sure that you understand what it is you have in your written policy and why. There were a couple of policies where I thought, well, good job following the instructions. I'm not left feeling like you know why you did this. And so that was a big part of it. At some point in the near future, and by near, I might mean a year or longer, we will have this as a requirement for you to even apply to the City of Loveland for funding. The City of Loveland has requirements as you do with language access plan, effective communication plan. We have our transition plan, translation of vital documents, et cetera, et cetera, et cetera. And one of the things that Bruce told me probably 4 or 5 years ago is, yes, Allison, but you as the community partnership officer also on the hook for ensuring that the people that we give money to also provide services that are accessible to everyone in this area. So we can revisit those ADA, non-discrimination and grievance policy plans. I think that it would be up to you to understand which of your documents are vital and need to be translated. And that is, in some ways a much easier ask because it's easy to get to a translation service. We would ask that, in the very near future, I would say that you have, as Bruce mentioned, a way for your customers to see your non-discrimination policies so that they are visible and in English and Spanish in large print, and a way for your customers to know that if they're unhappy about something, that they can file a grievance. So all that is really putting something on your wall and framing it. And then we have helped in the past with I Speak cards. We've emailed one like to Carrie most recently. We will laminate them. We will bring them to you. You can send me an email and say, I'd like 10 laminated, and I'll stop at your door and bring them to you. Then the heavier ask is for you to complete your language and your communication plans. And we don't yet know what we're going to provide in that arena. I received a copy of our language plan from our HR director who's on this meeting a year ago, or maybe not that long ago, and read it. And I thought it was just truly incredible. And at some point we'll have that online once it's been approved. We keep our plans online, so they should be accessible to you as well. And I can point you in that direction. I don't know that we will go so far as to help you write them. I don't believe we are planning on reviewing them, but at some point we will require that you have them. Tracy, does that answer it?
Yeah, that's really helpful. And then my next follow-up question would be from Bruce. And so Bruce, obviously you've outlined a process that you'd like us all to go through, but talk to me more about the specific elements that each component needs to have. I mean, there's a bare minimum, but is there, could we follow like a template to create an adequate policy that would meet all of our needs?
Well, let's start with the spoken language. If you begin with the survey that I mentioned to start figuring out
Yep.
what languages you encounter, that's a great, very important first step. But remember, in the earlier part of the webinar today, I went through 5 steps that your plan should have. Start with those. They will inform good places for you to go and start to get the beginnings of a plan put together, and to just boil it all down, both for effective communication under the ADA and spoken language under Title VI. The most important points are that you must have the ability to communicate with people who don't speak English and who speak sign language, for example. You have to be able to do that. So however you do that, we talked about various solutions, and I gave you my strong thought about video remote interpreting. You must have that. So if you have that capacity, you've trained your staff, here are all the phone numbers, here's how you access the program. You emphasize the non-racial profiling, emphasize you don't make assumptions about people based on disability. So in a very quick sum in a way, those are good places to start. And please keep in mind that, as Allison said earlier, the reason to do this, the reason to have the non-discrimination policies relating to language, aside from the federal legal requirements, are for you to enable yourselves to talk to your customers and enable them to talk to you so that they can access your services. That's typically the bottom line that the feds always look at, that the courts look at. Could Bruce access your services? Could he get, whatever services you're providing, regardless of language or disability? That's really one of the key questions. So if you look at this as a good summary to begin, and always keep in mind, look, folks, we got to figure out how to provide what we are providing to people who speak Chinese. How do we do that? We have to be able to provide services to people who are blind. How do we do that? So those are important questions, I think, to remember. And that kind of is, I think, a good synopsis of the most important aspects of what I discussed today. Does that help?
It does, but it also makes me think about our nonprofit is a post-secondary education model. We support single parents to go back to school to get a degree. And so inherently involved in that, they at some point are going to have to speak English to go to school.
Do you mean post-secondary school?
Yep.
Well, I mean, that's true, but whatever your services are, they have to be able to access them, since I assume you don't operate a post-secondary educational facility. So
We don't, but someone is not eligible for our program unless they are going to enroll in post-secondary education.
Okay. Well, I understand what you're saying, and I understand that your situation may be different than some of your colleagues, but the first part is you're offering federally subsidized services to people who want to acquire post-secondary education. So those services have to be available to me regardless of language. Frankly, post-secondary educational facilities have their own language issues that they are required to deal with that is kind of beyond what we're talking about today. But whatever services you provide, they must be accessible to people regardless of English proficiency. Does that make sense?
Not really, because if ultimately they're going to enroll in post-secondary education, we would not accept them into our program if they could not enroll in post-secondary education. Doesn't matter what language they speak. If that's not something they're able to do, they cannot enter our program and access our services regardless of language or able-bodiedness.
Well, I would say that this may be a little beyond what we're generally talking about today, and I'll leave it up to Allison if there's some, if she's interested in having a further conversation beyond our program.
Okay.
But the bottom line is that all federally subsidized programs, services, or activities must be available to people regardless of English language proficiency, period. How you do that is another issue, but that's what the law says. As I said, I'll leave it up to Allison whether she wants to have a further conversation.
And it's possible, Tracy, that you don't have federal funding. We don't provide federal funding to everybody who's on this call, but access to services is key.
I mean, I mean, let's just talk about this with a different scenario. Let's say that we serve women under the age, between the ages of 16 and 20 in some service. And let's say a man comes in and tries to access the service who doesn't speak English. What would it look like in that scenario?
Well, what type of service are you providing in your scenario?
In this scenario I just described,
Mhm.
let's say it's, gosh, I don't know, teaching them how to be a dog groomer. I mean, I
Okay.
don't know that it particularly matters. The point is the eligibility requirements are not being met.
Well,
And so they're not eligible for the program. That's my point.
I would say, and I know Queen has a question, and I want to get to that, but I'm going to, in a way, answer your question with an illustration that I recently encountered
Okay.
a situation involving a federally funded organization that limited participation in a program based on race, that they would not allow people of a certain race to be in the program. And not surprisingly, they got a lot of criticism for that, and they changed their eligibility criteria. I also advised an organization of higher education, actually, that barred men from applying for being involved in a particular program. And I told them, you can't do that. Title IX prohibits discrimination based on sex. You can't bar, if you're federally funded, a protected category from participation. So I understand where you're going. As I said, I'm going to leave it up to Allison for any further conversation, but there may be, I don't know what your eligibility criteria are, or really anything specific about your organization, but you can't bar people, whether implicitly or explicitly, if you receive federal funding, if they're in a protected category, from being able to access your program, services, or activities. So that's the general description of what federal law says in the context that we're talking about. Queen, did
So
you
what
have
I'm
a?
hearing is protected category is the key there, right?
Right. I mean, for example, let's say a protected category isn't being a New York Yankees fan, for example. Or I'm a Yankees fan. I'm originally from the Bronx. I'm not protected because I like the Yankees. So that is not a protected category. What is? Gender, race, color, national origin, language, religion, sexual identity, sexual preference. Those are protected categories. So you cannot bar people, if they belong to one of these categories, from being able to access your program, services, or activities if you receive federal funding, whether it's directly or indirectly.
Tracy, you and I can
Thank you.
keep talking about it and we can figure out what to do in your particular case. And we,
All right, I
honestly,
appreciate that, Allison.
we had this come up at the City of Loveland. There was an organization that applied for our federal funding. And their primary service was to help single moms. And they were doing some really good work with single moms. And when it finally sunk in, I said, yeah, we can't fund this because what happens if a single dad walks in? What happened, so if you're only working with one gender, then that poses a problem. We ended up not funding the project. Queen, do you want to ask your question?
Gotcha.
Yeah, thank you. Just to kind of piggyback off of what Tracy was mentioning in her scenarios, which were actually really good ones based on my lived experience with organizations here in Laramie County that I look to support my family and I. I was wondering, Allison, are we using any diverse and equitable partners to look over any like policies or stuff like that before funding? Because I would think in someone in Tracy's situation over at her organization, just thinking you can do something as simple as just change your policies. And I know that's not easy for every organization to just wake up one morning and change your policies. But when you notice that there's a barrier in you supporting any community member through your organization's policies, then I would think, can't we just like talk to you about changing our policies to get that funding?
And to find a way to do that, this has come up in the past. And Queen, I really appreciate that I think you added an additional element to this, because I remember years ago, I wrote a policy and somebody very different than me read it and thought, I can't even begin to tell you the ways that this is offensive. But that person did, which was very generous. And then I had the opportunity to change it. So there are two things that I see here. One of them is meeting the standard and the obligation for having a policy that is in place that's non-discriminatory. But Queen, what I also heard in what you said is having a policy that's not offensive.
Definitely that. I can clearly recall, going to agencies and asking for support, but unfortunately my resiliency just didn't align with what they had going on. I had to be inside of their box opposed to what I needed support for. So policy change could work. Thanks, Allison.
And Doug asked a question, is there a recommended record keeping strategy for interactions involving interpreters?
If you mean record keeping as far as the languages that the interpreters are encountering, yes, that's part of the federal funding recipients' overall data keeping requirements, is that if you have two interpreters encounters every day, you should be recording or have some record. It could be the language services provider can just give you their records. What languages were being spoken and what services were being accessed by the limited English proficient person. I want to mention very quickly, and I think that, being living right outside of Washington and having had my own experience in government, I really have to emphasize, it's something that I'm emphasizing with all my clients. The Biden administration is literally making changes every day. And I'm not exaggerating that. They are putting out all kinds of changes, whether they're direct changes or changes that they're anticipating. So it's also important from a mindset perspective to realize that there are different priorities that are being established now, or that will likely be established in the near future, that you may be used to. So I have recommended to everyone that I work with, please keep that in mind. The Biden administration is being unusually proactive, I would say, in making changes and making changes in ways that I haven't seen before. That example I gave you earlier about that highway in Texas is a great example. A $7 billion project being stopped. I've been a lawyer for almost 40 years. I was with the Justice Department for 6 years. Never heard of that before. So please keep that in mind. We are in a period of change. And I think that's a good way to look at it.
All right, so we have about 2 minutes left. Any more burning questions before we go? It doesn't look like it. Bruce, thank you for spending this time with us to get us all in the same room to have these conversations. I appreciate that. I appreciate your partnership. I appreciate really everybody who's been willing to take these 3 hours to join in this conversation. We know that these aren't easy policies for people to put together and easy changes to make. They are both time consuming and sometimes a very different way of thinking about how people access your services. And I believe, though, I strongly believe that in doing the work, we'll have a stronger community.
Great. Thank you so much, Allison.
Thank you.
And thank you, everybody.
Have a good day.
Thank you. You too. Take care. Bye-bye.
Thank you, Bruce. Thank you,
Thank you.
Queen. Queen, you have a unique view on our community, both because you lived on the East Coast where things are very different than I would say in Colorado. I appreciate that you keep your eye on access and equity. And I also truly, from the bottom of my heart, love and appreciate everything that you're teaching me. It's very, very generous. I know it's generous. I know that we both know you don't have to. And you make me a better person.
Sister, I told you from the beginning, we are both God's children. So in order for this work to get done, we have to engage one another. I've got to do my part and you have to do yours. And I truly love being in community with you, Allison. This is really a teaching journey for me as well. It truly is. I've never had someone that looks like you to have a heart like you. So you give me hope that there are so many more people out here like that. And it seems like Bruce is one of them because
You can
you
count
did
on
an
me.
awesome job
Thank you.
on this training. I am
Thank you.
so, that's why I stayed. I am so grateful, brother, for you bringing us together and doing this because you're making us think. And that's what we need to do. We need to think collectively. So I'm grateful to you.
Oh, thank you.
He's
Well,
held my hand through a lot, Queen.
Thank you.
Yes.
I very much, Queen. I really appreciate your comments last week and today. They hit home perfectly.
No doubt. We will continue to work together and we will get Colorado right. Yes, we will. Don't you do that to me, sister.
I'm
Don't
not
you
scared
do
of
it.
writing down.
You guys have an amazing day. Thank
Thank
you,
you, you
Allison.
too.
Thank you. Thank you.
Take care.
Bruce.
No doubt. Thanks,
Bye-bye.
Bruce.
Bye.
Thank
Bye-bye.
you. Bye-bye.